I mean, he very well may have. Doesn't look like the same old toe, does it?
Calling line 7 on the in custody calendar, state of Minnesota versus Aaron Michael Imholte.
This is court file number 73CR246910. We're here today for a first appearance. Just a reminder to anyone that is in the hearing room today that while this is a public hearing pursuant to General Rule of Practice 4.01, there is to be no recording of any court proceedings except the official court reporting and recording that is done here in the courtroom. Any violation of this court's rule that no recordings should be taken of this proceeding is punishable by contempt of court, including jail sanctions. Furthermore, any disruptions to this hearing will also be considered contempt of court and may be punished by contempt of court sanctions. The court expects all hearing observers and participants to follow the court rules, just as if you were present here in the courtroom. We are here today for a first appearance. Mr. Peterson,
I'm not recording it.
Mr. Imholte's rights as well as the allegations.
I have, Judge. We waive reading.
Thank you. Combined with Rule 8 today.
Judge, we agree to accept Rule 8 materials by mail, and we would ask for an omnibus hearing.
Thank you. Ms. Darlene, as to release conditions.
The state's requesting $100,000 unconditional or zero monetary bail to standard conditions to include not leaving the state of Minnesota without court permission, no contact with KCR, as well as a 500-foot residency restriction.
$100,000 bond.
Prohibited from directly or indirectly talking about, disparaging, and/or harassing KCR online, on social media, and/or during any online broadcast show that he participates in or has control of. I believe Your Honor has read the complaints. I won't go into that specific information, as the court's well aware of the circumstances of this case. I do believe that the conditions as requested are appropriate, given the overall circumstances of the charges, as well as additional information.
$100,000 bond!
Online broadcasting. He does also have a history of not abiding by court orders and no contact orders specifically, and violates them via an online broadcast show that he does have. He does have an HRO in place protecting a different individual. He recently was sentenced for an HRO violation. That violation circumstances were violations via his online broadcast. And so I am asking for that specific condition regarding not directly or indirectly talking about KCR in order to protect her from further harassment. And also, if that does occur,
well, there goes the show.
I would note that I did look up case law regarding a condition specifically regarding this. I could not find anything on point in Minnesota specifically, but I did find a Second Circuit Court of Appeals case where a similar condition was imposed. The Second Circuit Court of Appeals did find that it would not violate freedom of speech as it was reasonably related to the nature and circumstances of the offense, as well as it was narrowly tailored and only restricting discussion regarding the victim in that specific case. I did pull the direct language from the defendant's HRO protecting a different individual. So that's the same language that I believe it was out of Sherburne County ordered regarding that individual. And so I'm asking that it also be in this case for KCR. Additionally, I would ask for omnibus to be held within time. And I believe Mr. Peterson and I both are requesting that that be in person.
Thank you, Mr. Peterson. As to release conditions.
Judge, it's my understanding that my client has a single misdemeanor conviction concerning a harassment restraining order. The current charge, the most serious charge,
but Your Honor, I talk about the news in my life, and my life is the news.
Of 3 years in prison. I say this for context concerning the severity of charges compared to other more severe charges. My client is a homeowner and has lived in Minnesota all his life. He's 37 years of age and divorced. with 3 school-aged children. He has an Associate of Arts degree from Brown College, and is the owner of Steel Toe Media. He advises me he has no felony record, no record of crimes of violence, with the exception of the single misdemeanor HRO that the prosecutor mentioned. This matter went out as a complaint warrant very recently. He retained me on Friday, and we had a plan for him to turn himself in this morning so we could address conditions of release. I would suggest that the request for $100,000 unconditional bail is excessive. And while we agree that harassing comments are inappropriate, I know this has to be balanced with a person's constitutional right to fair speech and any free speech, and any prohibition on speech should be narrowly tailored. That's all I have. Thank you.
Thank you, Mr. Peterson. I've read the complaint. I reviewed the allegations. I think because what the court is most interested in ensuring here is that Mr. Imholte understands and is going to abide by the court's orders to not harass or have any contact with the alleged victim here. I do think that substantial monetary bail, which if posted would not come with the same conditions, is necessary to ensure that he continues to make court appearances and continues to follow the court's orders moving forward. So I do think some substantial unconditional bail is appropriate. I'll set that at $75,000. In the alternative, he can be released today without having to post any monetary bail, but he is to he is to remain law abiding. He is to make future court appearances. He is to keep in contact with his attorney. He is to keep the court updated of any change in his address. He is not to leave the state of Minnesota without permission of corrections. He is to not have any contact with the alleged victim in this case, KCR. He is to stay 500 feet away from her residence. The court is also going to order that he abide by all active harassment restraining orders, and also that he is to not have any indirect communication with KCR, which would include making disparaging comments specifically about her or harassing her on any medium, which would include in person, over the telephone, text message, online, social media, or broadcast through any podcasts or similar online shows. The court does believe that restriction on simply not mentioning KCR is narrowly tailored to relate specifically to the rights and safety of the alleged victim in this case. So I will impose that condition as requested by the state. We'll set this for an omnibus. It will be an in-person hearing. Ms. Darlene, anything else for the record?
75K.
Can I just clarify regarding the restriction, regarding the communication online or by any other means? Your Honor did say indirect. Would that also include direct?
Of course, yes, direct or indirect.
Thank you. I just wanted to make sure that the record's very clear about that. Otherwise, I have nothing further.
Thank you. Mr. Peterson, anything additional?
No, Your Honor.
Demanding speedy?
We are not demanding speedy, Judge. I discussed this issue with my client, and we want to thoroughly review and investigate the case. I also have some other matters in September that could be at least one lengthy trial. So for those reasons, we're not asking for a speedy omnibus hearing within 28 days.
All right, thank you. We'll set this matter without regard to time at this point.
The state is asking for it to be within time. And if there's any specific conflicts, Mr. Peterson and I can discuss with the court clerk.
We'll note the state speedy request, and then the next hearing date will be set in coordination with council. I believe that addresses everything for the record. Thank you for your appearance. This will conclude the hearing.
Thank you.